And they went for a sidebar. So what we're going to do now is we're going to bring in one of our guests via Skype. It's Randy Kessler. He is a family attorney out of, I believe, Atlanta. Am I correct there, sir?
Yep.
Welcome. And I know you've been following the case of Tennessee v. Tremaine Wilbourn. And, you know, right now we haven't heard, we've heard from various witnesses who saw different parts of what transpired before, during, and after the shooting that eventually took the life of Sean Bolton. And I guess the question I have for you is this an uphill battle for the defense? I mean, we're dealing with not just the question of guilt. Obviously, the next question is going to be, if it gets to that, whether or not the death penalty is appropriate. But let's just start with guilt for a moment. What are you thinking based on what we've heard so far?
Oh, I think there's guilt. I think we're way beyond guilt at this point already. And again, yeah, I'm a family lawyer, and we have jury trials here in Georgia, so I also teach a jury trial class at Emory Law School, so this is really interesting to me. But I think what they're trying to do is personalize this and make it not just a factual kind of, he shot him 8 times and he died. This is a real person. The people around it saw him. The people that were before, during, and after. They're creating a picture. They're creating a movie for the jury to go back and mentally visualize what happened. It makes it worse than just a, yes, he pointed a gun and shot somebody. And I think that's going to help because emotion is a part of any trial.
Sure, and I think one of the biggest issues is, I think what the defense is trying to do, again, I think they're kind of probably grabbing at straws, but what they're trying to do is maybe create some type of self-defense. I'm not sure that self-defense would fit in any way, shape, or form in this case, but by confusing the jury about what transpired right before he was killed, it may raise some kind of doubt as to whether or not the officer was shot during the course of the defendant resisting arrest. I don't think they have much of a shot at that, but, obviously the defense is dealt the hand they get, and they're doing the best they can.
So I agree with that, but, the other hand that they're dealt is the jury, and you don't know what biases or what baggage the jury has. If there's a jury that says too many of these incidents go where they're just sentenced before there's even a fair trial, and the jury is looking for an excuse to let this guy off the hook or to find him not guilty, then the defense has to give them something. That's right. And you may be right. They may be offering something to say, if you want to find him not guilty, here's how.
And I guess, whenever we talk about these cases, especially as a defense attorney, you have to always be prepared with the idea that death penalty is potentially in the future. And so, one wonders, because, I practiced in New York my whole career, where death penalty, except for a very short period of time, was never on the table. And one of the things I think is the toughest for defense attorneys is balancing how they portray their defendant, their client, at the time that the trial is happening, and preparing the jury for the potential that they're going to be talking to them again more than likely at the death penalty phase. And that's incredibly tough when on the one hand you're trying to prove that he's not guilty, and then on the other hand you have to take that new phase where you're saying he's guilty, but please, please don't put him to death.
Right. If you were worried just and only about the death penalty part of the case, you would say, I'm guilty and I'm sorry, I should have done it, and I wish I hadn't done it, and this is why I did it. But any of those statements help convict him. First, got to try to make sure he doesn't get convicted. And then you're right, they've got to turn the corner from he didn't do it to, well, I was lying about that, I did it, but I'm sorry about it. And that's a hard corner to turn. So they've got to humanize him. They've got to make him feel sympathetic to the jury. And you're right, everything he does is looked at by the jury. They can see him. They can see when he winces. They can see when he laughs, when he smiles, when he winks. So all that stuff is very, very important, if not for the guilt or innocence, then at least for the death penalty portion.
A very tragic case in the death of Sean Bolton, and very difficult case for the defense. Difficult case for the defense. We're going to be right back. We're going to see more. And they're taking a break over at Tennessee v. Tremaine Wilbourn. What we just heard from was the testimony of Wilton Cleveland. He was the forensic cell phone expert, and basically he didn't testify to much. What he testified to was that there was a phone that was recovered and that he did an analysis of the phone to make a determination as to whose phone it was, and it appeared to be the phone of the defendant, Tremaine Wilbourn. It also sounds like he was able to get photos from that phone and sent them to the NYPD. Although it's odd, I don't know if you were following this, Randy, is that usually you would hear what those photos were, and we didn't hear anything about that. I assume that the suspense will eventually be relieved and we'll find out what they were.
Right, or, it seems pretty extraneous. But again, this isn't mathematical stuff. If you wanted mathematics, you'd say, you'd talk about the gun, you'd talk about eyewitnesses, and that would be it. You wouldn't need this extra stuff. You might be handing the defense something they can use because, as we all know with the O.J. Simpson case, the longer it goes on, the more the defense can find fault with the prosecution's case. So maybe this witness stumbles and doesn't remember something. He turned out to be a good witness. So they got to be very careful, and they did keep it short and to the point. But who knows maybe you're right. Maybe they're going to tie it together, or maybe they had another witness that was running late, so they put this witness on now.
Right.
How a trial goes.
Right. I mean, yeah, usually, look, in New York, when someone is the one who finds the photos, they're the ones who testifies to what the photos were. It seems to make more sense, but, I never understand the logic of how any other cases go, including the ones I've dealt with. We were talking a little bit before about the idea of this being an eventual death penalty case. And one of the things we've learned about this defendant, and obviously the jury doesn't know much of it at this point, is that he was on probation for another case in which he had done, I think, 10 years. That in the vehicle that he was driving was drug paraphernalia and I believe a small amount of drugs, which may explain why it was that he didn't want to get arrested that day, although it seems quite extreme that he would take the life of an officer in order to avoid being arrested. And that he had, even while incarcerated, it seems like he's continued to get in trouble again and again and again, even after committing this absolutely heinous crime. Maybe I'm begging the answer to this question, but how is all that going to, allow or disallow the jury to make a real fair decision in regards to whether or not they're going to be willing to spare his life at the end of the day?
Well, ultimately, it should really come down to this incident. Obviously, look, again, to go back to the O.J. Simpson case, did he get convicted in Nevada for the robbery based on the facts of that case, or did the jury still have memories of his other stuff? This other stuff seeps into the jury's decision.
Sure.
But the bottom line should be, does this crime deserve the death penalty? If you look at this other stuff, you can explain a lot of it away. This guy is probably going to be facing the death penalty. He's been there before. He's acting out in prison. He's not the model citizen by any means, not the model prisoner by any means. But does that affect this? I think it's a distraction. I think the prosecutors have enough in this case. He murdered somebody. That might be enough for anybody else to say death penalty. But he murdered a law enforcement officer. He has all these other issues going on. He didn't just shoot him and by the way he killed him. He shot him a bunch of times. He was angry. There's just so much there that I don't see how he gets away with not facing the death penalty unless you have one person on the jury that is just dead set against putting anybody to death unless they are convinced, not beyond a reasonable doubt, but beyond any single doubt whatsoever. Defense has got to hope for that miracle win, and it happens sometimes.
Yeah, I couldn't agree with you more. I think the biggest problem that this defendant has is that there's such a lack of mitigation that at least we know of at this point. We don't know if there's going to be things that come out about his childhood that at least garner some level of emotion from one juror or two jurors in terms of maybe a tough life that he led. But it seems like from beginning to end, he has yet to show any level of remorse in any way, and certainly, even while incarcerated, has done nothing in any way to mitigate the absolute heinous crime that he committed, including the fact that, you're absolutely right, he didn't shoot him one time or two times to get away. He didn't need to shoot him all those times in order to get away. And I don't know how a jury is going to look at this in any other way. And I'm not usually the death penalty advocate that sits up here, but I think a jury is going to have a really, really tough time figuring out how to avoid the death penalty. And of course, this is assuming, and I hate doing that, but inevitably we tend to sometimes, this is assuming we're going to head to that phase.
Right. I think we got to assume that because that's, the more interesting issue to discuss. Is he guilty or not? I think we all think he's guilty. From what we can see, he looks very guilty. He looks beyond a reasonable doubt guilty. But, you hate to keep harping on the more than one shot. Could he have said, oh, my God, I'm going to get arrested for this. I'm going to go back to jail. I'm going to shoot to get my way out of this, shoot the guy, disable him, and then run. Not that that's understandable or explainable to you or me, but a jury could see how he could have done that. And, oh, gosh, the guy died. I didn't mean to kill him. I just meant to get away. he lost that defense. He lost any kind of defense of, I was just scared, I reacted, I didn't think about it. I mean, boom, 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 boom. I mean, it's just incredible. There's no way, in my opinion, that the average person is going to think he doesn't deserve the death penalty. But then again, I have my background, I have what went on in my life, and everybody else has theirs. You don't know what everything to these jurors happened. I mean, they try to do a good voir dire, but you never know what some little issue some juror might have in the back of their mind. This defendant reminds them of a distant relative who they just think that giving him the death penalty almost feels like they're giving the death penalty to somebody they know. I mean, there's just so many little things you can't escape, but all things being equal, it certainly looks like it's headed towards a guilty conviction and a death penalty sentence.
You never know who your jury is until they make that ultimate decision. So, you know, we're on a break from Tennessee v. Tremaine Wilbourn. We're going to take our break ourselves, and we'll be right back. And welcome back. We're watching this is Willis Koehn. He is the father of the defendant Zachary Koehn, and he's testifying on cross-examination. I'm here with Ashley Wilcott, who has taken the other side. Thank you for coming back to join us. And just, you know, a couple things that we learned so far from hearing from at least this witness is that he describes there being another child that had been in his care, who's older than the two that we know that Zachary Koehn had. And he also testifies a little bit about his religion, which kind of were some buzzwords for all of us when we were listening to it. Why don't you tell us a bit about that?
So here's my thought, is I think the defense is going to use this now to say in that particular religion there's a belief and an understanding and a culture that the woman takes care of the child. And so I think the argument by defense is going to be, look, this is his religious upbringing, the woman should have been taking care of the baby. I have to tell you, to me though, it begs the question to hear that he already gave a child to his parents, because why would he not have done the same with the 2-year-old and definitely the 4-month-old that is now deceased in order to get help if he knew his wife wasn't doing what he expected her to do as the caretaker? It still doesn't make sense to me. I don't think it's a sound defense, but I think that's where they're going with it.
Yeah, and I think, look, I mean, at the end of the day, as defense attorneys, we look for any defense that's potentially going to get our client out of at least the top charge. And the question becomes for me is some of these defenses, whether it be the postpartum depression defense or the issue of now the Mennonite defense, seem to me to backfire, because when we start talking about postpartum as you move up, I'm slowly seeing you move over.
We're getting some guidance from the control room. I apologize.
I apologize for that. As we talk about postpartum depression, one of the things we talk about is if she had postpartum depression and he knew about it, then that would make it all the more important that he engage in the care of this child. So I don't know that any of these defenses really hold any bit of water. And quite frankly, the father even said that he knew, Mennonite or not, that his responsibility was that if the mother couldn't care for the child, that he was obligated, and we all know that you're obligated to take care of your kids.
Absolutely, and obligated to take steps. So by taking steps, what he could have done was, for instance, given the child to someone else. So as a juvenile court judge, I see abuse and neglect cases, regrettably, all day long when I'm on the bench. And this happens time and time again when parents fail to act, and by failing to act, their child is injured or dies. And that's what happened in this case. And in my mind, there's no reason he is not responsible for that death, regardless of who he thought should be caring for this baby.
And Randy, let me pull you in if I can, if you're still there, Mr. Kessler. You know, do you think that the testimony of Willis Koehn is helping the defense or helping the prosecution?
Boy, I really don't know. It might make the jury understand this witness or the defendant is really not one of their peers, that he's somebody who is dependent and deficient in some way. Maybe he did just have such a, you know, attitude about, it's the mom's problem, it's the mom's responsibility. He definitely didn't have experience, and he, you know, I don't know which way it's going to go. All I know is it makes the people on the jury say, none of those people are going to be around my child, and that guy deserves some sort of punishment or some sort of correction in his behavior. I don't think it helps him more than it hurts him, but you never know what a juror is going to latch on to. If someone on the jury says, that reminds me of my family, well, all of a sudden the defense might have a winner. They may have gotten lucky. You never know.
And so, yes, you're absolutely right. And obviously the jury's going to be the ones that are making the final decision. We're going to be hearing more from the defense case in a few minutes. We're just going to take a break. And welcome back. That's Danny Koehn on the stand. He is testifying for his brother, who has been accused for the murder of his 4-month-old child. I'm here with Judge Ashley Wilcott. Judge Ashley, thank you for staying with me. We've been talking kind of throughout this. There's so many things that are going through my mind, and one of the things that we were discussing is it seems now that the defense is raising the issue, as we talked about a moment ago, about the fact that he was a Mennonite, and therefore the mother was the one who cared for the children. And at the same time, it seems that they're also throwing in that postpartum depression on the part of Cheyenne, the wife, as being possibly another argument as to why the jury should let him off the hook. And my position has been, at least when it comes to this case, that the defense should have picked a lane. Because if they had started with the Mennonite thing, maybe it would hold some traction. But I'm having trouble seeing it now. Tell me what your thoughts are.
The same thoughts, Julie, exactly, because when they did opening statement, the defense, as you recall, they specifically said during the opening statement, we're not going to tell you what the evidence is going to show. Instead, we want you to keep an open mind. This is a horrific, horrific death and tragedy, and listen to the evidence presented. Now that we're hearing it, I guess part of my concern or caution is you can't say because of a lack of formal education someone's going to abuse and neglect their children. You can't say that because of their religion they're going to abuse and neglect the children. And so putting all that, you can't say because of postpartum someone's necessarily going to abuse and neglect. So you put all these things together and it's dangerous territory. It's accusing people of doing these things because of those things. And I think defense is really needs to pick a lane, and it's a little, I don't know they're going in a good direction.
Yeah, you know, you know, to add to your point, the cross-examination is basically saying, 8th grade education or not, you entrusted him to take care of your own children, and he could do that. And so the question becomes, well, why on earth, when he had a child that was sitting in diapers with, you know, the most horrific of circumstances, did he choose to pay absolutely no attention to that and decided instead to use drugs on a daily basis to avoid kind of that responsibility? Let me just bring in Mr. Kessler, Randy Kessler, for a moment. You know, I think that the defense has kind of lost their traction, and their traction could have been from the start to kind of take this defense and go with it. And to me now it seems like kind of an after-the-fact thing, and I'm not really getting where they're coming from.
You know, desperate times call for desperate measures. You know, it's always better to have one good theory and try one good theory to make it work. And if you don't have one good theory, then they're trying everything. And who knows what jury member might pick up on something. They're obviously desperate. They've got bad facts. They've got an ugly situation, an ugly mental picture. You know, his brother looks very rational. His brother looks very normal. You know, why did he get the normal genes and the other brother didn't? I mean, who knows how this is going to play out? But I guess the longer they stretch it out, the chances are better and better and better. And maybe they'll find a little loophole or an angle or a hook or something. Because right now I don't see an innocent or a not guilty verdict based on what I've seen so far.
And remember, keep in mind, ladies and gentlemen, that this is a murder in the first degree, which does not require intent. It requires basically the endangering of a child, that a child died as a result of the lack of care. We're going to take a break, and we'll be right back. And welcome back. We're listening to the testimony of Greg Nightingale. He is testifying for the defense on Zachary Koehn. And we're going to be letting Randy Kessler go. Randy, thank you so much for being here and giving your expert advice from the beautiful, beautiful place called Atlanta, Georgia. You were kind enough to show me from your window. I'm a little jealous right now. But we're going to go to a break, and we'll be right back.